What the CCPA wants to do is make sure that not too much is being taken out from a debtor's paycheck each week, because that then just results in more financial issues and more strain. So what it says is that the maximum part of disposable earnings, we'll get to what that is, of any individual for any work week, uh, which is subject to garnishment, may not exceed the lesser of 25% of disposable earnings for that week. Or, it's a little complicated, we'll walk through it, the amount by which disposable earnings for that week exceed 30 times the minimum wage.
Welcome to Mission to Grow, the small business guide to cash, compliance, and the war for talent. I'm your host, Mike Vanoy. Each week, we'll bring you experts in accounting, finance, human resources, benefits, employment law, and more. You'll learn ways to access capital through creative financing and tax strategies, tactical information you need to stay compliant with ever-changing employment laws, and people strategies you need to win the war for talent. Mission to Grow is sponsored by Assure. Assure helps more than 100,000 businesses get access to capital, stay compliant, and develop the talent they need to grow. Enjoy the show. What every small business owner needs to know about garnishments. This is an area where I think especially small business owners that don't have maybe an HR department that is SHRM certified, they know all the rules of what you can and can't do here, that small business owners, I think, feel put into an uncomfortable place. It's pretty common that a smaller firm, you're trying to grow, but you got personal relationships with your employees, and there might not be many layers of management between you and those frontline employees. And so all of a sudden you get a notice for a garnishment. It's like, what do I do? I can't not follow the law. I also know this person. I know their personal situation. Maybe I even know the reason why they got the garnishment. And I know damn well it's not their fault. It's that dirty, rotten scoundrel who's done something to them. What do I do? Because they feel trapped in the middle. So a really important topic that we need to unpack so that small business owners understand what they can do, what they can't do. Most importantly, what do they need to do to stay compliant? Got a great guest. If you're a regular watcher of the show, you know Brian Shenker from Jackson Lewis, an attorney specializing in HR law. Welcome back to the show, Brian.
Thanks for having me again, Mike.
So, garnishments. I think people generally know what it is. Maybe let's start out with, what is a garnishment from a legal perspective? Who's the governing body? What do we need to know just to start this conversation?
Yeah, perfect starting point, right? So each garnishment is really a court order or some type of other, judicial order that requires an employer to withhold money from one of their employees' paychecks for money that employee owes to some other creditor, right? So often, as you suggested, these monies are due for something like child support or student loan payments or unpaid taxes. There can be numerous reasons, but through the wage garnishment order that is served on the employer then becomes responsible for deducting a certain amount of wages and then transmitting them to the creditor. And so, there are different types of these, as I said, for different reasons, like child support, which may be, treated differently. But the key here is that these garnishments are coming out of state procedures, right? There aren't going to be federal garnishments. So, these are going to come from a local court or a state court. And there's going to be, directions on the garnishment itself or from the state on how to treat it. But all employers need to deal with something called the Consumer Credit Protection Act, which is the federal statute that governs garnishments, in addition to whatever state limitations there might be.
So interesting, it's a little paradox there. So it's garnishments come from states and local municipalities, right? Local judge, county judge, state judge issues an order. That could be a child support order. Could be we'll unpack the different types, but could be you lost a lawsuit or fine, or it could be a bunch of different things. So it's not the federal government doesn't issue garnishments or demand garnishments, but the federal government does govern this with the CCPA, the Consumer Credit Protection Act. That's interesting. How is it that a federal agency governs something that's driven by states?
Yeah, so great question. And that's a so I'll explain how this CCPA came to be because the purpose of the act was essentially to mitigate the sometimes very harsh effects of state garnishment laws. What Congress found, and this was back in the 1960s, where the CCPA became effective at the very end of the 1960s, but what Congress found was that states that had the highest rates of personal bankruptcies were also very liberal in how they permitted wage garnishments. So Congress saw a connection between that, and what they wanted to do by the CCPA was really limit how much could be taken out of an employee's wages for garnishment so that they could still survive on some minimal amount of income. So what Congress really did was, right, they exempted certain amounts of weekly disposable income to ensure that employees retained, the weekly minimum living allowance. Um, and they also provided that under the federal law, an employee can't be discharged, can't be terminated for having a single wage garnishment, right?
Mm.
Because as you mentioned, Mike, being served with a wage garnishment, especially for a small or mid-sized business, often something they've never dealt with before, something they may not want to deal with, but under the law, you may have to. So
Yep.
there's often an idea from employers, well, let me separate from this employee. I can avoid dealing with the administrative burden of this. The CCPA says, no, you can't do that. Like you said, there's also the opposite response from employers saying, well, this is, my loyal employee for, 1 or 2 decades. I'm being told to take money away from them. I don't think that's appropriate. I want to pay them all their money, but you're bound by a wage garnishment. And as we'll
Yeah.
discuss, there could be consequences for ignoring it.
Yeah, and we'll unpack that. So that's helpful. So let's maybe just make sure everybody's grounded on what is a garnishment. What makes a garnishment different than another type of, say, payroll deduction? What's compulsory about this for the employer? Just maybe give us a tight definition.
Yeah. No, and so the meaning of garnishment is very important in this context because if an order qualifies as a garnishment, then it is subject to the protections we'll discuss, which are limitations of how much money can be taken out of the paycheck. But if it's not a garnishment, then it's not subject to those limitations and more could be taken out. So it's very important, right, whether it's a garnishment. So the CCPA, defines it pretty broadly, and it's really any seizure flowing from judicial action, right? So most of these are going to be court orders, but it could also sometimes be, something from, for instance, a government agency, right? Like, uh, you know, um, taxes, things like that. But interestingly enough, the CCPA's wage protections don't apply to bankruptcy court orders
Hmm.
or to state or federal actions to collect taxes. They're allowed to go after more money. However, in practice, the IRS will really limit itself to the amounts that this federal law, the CCPA, allows, even though they're not otherwise restricted.
Okay.
Yeah, like I said, um, really, if we're talking about statistically, what companies are more likely to have wage garnishments.
Yeah.
So just a matter of fact, it's going to be typically middle-aged adults, right? We're talking, that 35 to 44 age range. Why is that? That's because that's the time in someone's life when, one, they might be most likely to go through a divorce, which can often lead to child support orders. But it's also a time of life when people have, the most likelihood of, filing for bankruptcy or dealing with a lot of other debt. So that's the
Yep.
age range that we see most of these. Um, we see it mostly more so in men than women. Though that's somewhat a result of child support orders,
Sure.
but again, some of this is older data, so that may be changing. And then industries with the most garnishments that we typically see, manufacturing, transportation and utilities, construction. So
I mean,
again,
really, that's just math. If
mhm,
you know, no judgment. It's just if the majority of garnishments are against men who are paying child support, it would make sense that industries that are more male dominated employment would have a higher rate.
right.
Yeah.
Exactly. And so some of our listeners might already be experiencing this, based on their the makeup of their workforce. But that's not to say, that, this isn't to say women are not affected by wage garnishments. They absolutely are,
Yeah.
as are, individuals younger than 35 and older than 44. And Mike, as you suggested, right, these often relate to life experience, things that the employer will know about, right? So
Right.
it does sometimes put an employer in an awkward situation because the employee may be contesting something and they might think it's wrong, this judgment, and the employer might know about this and be on their side, but then they get this garnishment
Let's,
and it's not up
let's
to the
spend some
employer.
time on that because we're going to talk about the CCPA's cap on how much you can take and whatnot. But I just know firsthand talking to business owners that this is a real thing. It's like, okay, this employee, I just got a notice for a garnishment. I everybody in the building already knows this person's personal story, and we all might agree that they're getting screwed here. This is not fair. They're living paycheck to paycheck. I can't possibly take
Right.
more from them because I know them. I know the other person who's the offender here. I mean, there's lots of personal knowledge that happens to these things in a desire for an owner to arbitrate right versus wrong and take care of their own. Um, I mean, I
Right.
think the law's I think you're going to give us a very black and white answer. What must owners do when they get these notices for garnishments?
Exactly. So yeah, so let's go through that. And you're right. Let's put off the specifics on the amounts and other
Yeah.
details. But what do you do, right, when you get a garnishment? So here's the process, right? A creditor, right, could be a credit card company, could
Yep.
be the former spouse. Some creditor obtains a judgment, right, which says they're entitled to some amount of money. The creditor then obtains a garnishment order from a local court. So then a garnishment order, it's a piece of paper. It then gets served on the employer. So the employer receives this. It now has a garnishment order. So first thing you're going to do is have someone either in HR or finance, someone who can understand these types of things, have them review it. Again, if you even need to, discuss it with a HR consultant at Assure, you would do that. You want to understand what you're looking at. So by receipt of that garnishment, the employer becomes a garnishee, which means the employer must answer that garnishment order and then withhold certain amounts of money, and then turn over those certain amounts of money to whomever the garnishment order directs.
Yep.
And so that first step, right? You need to answer the order. So before answering the order, some states, and it would typically be contained on the garnishment order, will state that there's a notification requirement to the employee. But not all states require notification to the employee that you've just received the garnishment order. That said, as a best practice, you can imagine it is a good idea to notify the employee before you're going to make that first garnishment, the first deduction of wages in that payroll.
Yeah.
Because they're about to see something they might not expect on their pay stub. It's good to let them know it's coming.
So,
And
Brian, it's not a legal requirement, or is that state by state whether you are legally required to notify?
right, state by state, it depends on the state, but even without a requirement, it's a best practice to notify the employee.
Now, I'm
Uh,
assuming you're going to also share. Let's what would be a best practice? There's a right way and a wrong way, better ways, worse ways to notify that employee. There's some very obvious bad ones, like in a public setting, because these could be very embarrassing
Yes.
situations for employees.
Yes, no, and that's the number one thing, right? This is obviously a sensitive issue that relates to some other issue in their life. So this is something, pull them into a private discussion. This is a closed door meeting.
Yeah.
And yeah, unless the state requires it to be in writing, I think verbal notification is fine. They might need to know who the creditor is. But sometimes it's, not only notification so that, they can expect to receive less net wages on their paycheck that week, but it's also so maybe there's an issue. Maybe this was a judgment obtained on default that the employee didn't know about. So it allows the employee to then go and challenge the garnishment if need be.
Yep.
But remember, as an employer, even if the employee says, this is, a fraudulent garnishment, this says, whatever they might say, the company can't change anything it does based on what the employee is saying. Only until, the company needs to respond and can take out deduct the wages until it receives another order in writing from the court that issued the garnishment telling it to do otherwise.
Yeah.
So as the employer, you're really stuck in the middle. You can't really get involved in any dispute over the garnishment. You just follow the garnishment until you're told to do otherwise.
Real life story. I know a business owner. I was talking to this woman. This is maybe 5-6 months ago. She got a notice for a garnishment. It was credit related. A creditor coming after her. She knew what industry I was in. So she was asking my thoughts. The employee said, "Oh yeah, you know what? I'm embarrassed by it, but I actually just settled that. You don't have to take that out of my account because it's our." I mean, I know what your guidance is going to be, but I think that we need to be black and white in our recommendations on this show. So,
right,
what does the employer do?
Right, you're absolutely following what the garnishment says and not what the employee says. And then that would apply even if the employee's attorney were to call the employee and say, I'll have my attorney call you. And the attorney calls and says, hey, employer, it's all right. We got this settled, or, some other issue. You can listen, but you're not going to change what you're doing because of that.
Yeah.
Right. Again, the garnishment will come with the contact information for the appropriate court or agency, right?
Yeah.
So often it requires a response at the outset, even before the wages are garnished. But look, if you have any questions, right? If the employee says that, oh, this was settled, or the attorney calls, then feel free to reach out to the garnishing court with a question. There's typically someone there that will engage with the employer. But again, that's not necessarily the employer's responsibility to proactively do anything in that regard, right? If the employee is challenging it, they and their attorney need to challenge it through the legal methods. And if they're successful, as the employer, you'll receive a notice from some court telling you, stop garnishing the wages.
Yeah.
And until you get that, you continue garnishing wages until you garnish the specified amount, or you get that notice from the court.
So we're going to get into more details, but I mean, the basic punchline is this: if an employer gets a garnishment notice from, could be a Secretary of State, it could be a local court, some governing body, it gives you a notice, you have to act. It's a best practice. Maybe some states require, some don't, but best practice to privately communicate with the employee what this garnishment is, so it's not a surprise to them if they say, oh no, it's settled, or you can't do that to me because I can't afford such and such. You don't have a choice. You must follow the law. You must follow the garnishment, and you must then pay that deduction to pay from the employee. You don't get to sit on it for, oh, I'll pay that bill when I want. You got to pay it as ordered in the garnishment, right?
Exactly. And that's the key, right? That as soon as the company gets it, it's not, hey, we'll get to this in a couple payrolls from now. Uh, it would apply to the very next payment, the very next payroll. And if the company doesn't put these things in effect and start deducting, the correct amounts, there can be liability on the part of the employer. And so, if your company receives something and you're not sure if it's a garnishment or what it really is, because again, there's no standard across the country for what a garnishment looks like,
Yeah.
because it is state by state, and there have been attempts to create a uniform way of issuing garnishments, and uh, but those have not caught on. No
I
state.
suspect that not even the same within a given state.
Exactly, right, because one local a county court, downstate versus, a district court upstate, right?
Right.
They're all gonna be different, and so, sometimes you may even need to, reach out to an HR consultant or an attorney just to understand what it is you're looking at. So, again, this is an area where it's certainly okay to ask for help, and it's one of those areas where even if you listen to everything today and it clicks, you may still need to, get advice in the future. It might be unclear if it's a garnishment or what's actually being required of.
Brian,
So
is it safe to say? I mean, my experience in any matters like this, the judge says you must do this, or there's an HR law in the books that says you must do this, or IRS says, hey, here's your tax bill. In any of those cases, ignoring it is a terrible idea. Delaying it and not telling them is a terrible idea. But for the most part, if you're unsure about what to do and, hey, I don't know if I understand these instructions. Hey, what is this for? This is the first time I've ever received anything like this. Your letter seems black and white, but is this even real? I just wanted to check. I think you can't go wrong. I think these bodies are, maybe forgiving is a wrong word, but they will work with you as long as you are proactive in your communication and sincere about trying to understand what it is that they're asking you to do. Is that a fair statement?
yeah, exactly. No, that's fairly accurate. And look, the creditors may also reach out to the employer, make sure they received it, and but yeah, and it's something where the employer can go wrong on multiple fronts here, right? Ignoring it would be the worst thing.
Yeah.
And then, as we'll discuss, taking out the right amounts and not too much and not too little, right? There can be problems for employer that does either, right? If you deduct more for the garnishment than required, right? That could result in some issues with the employee, right? Maybe you've garnished too much. Now there's a minimum wage issue because now they're not even earning the minimum wage based on the amount above the garnishment that you took out, right? There could be issues like that, or you take out too little. There have been courts that have held the employer was responsible for the entire judgment against the employee, right? There's a in Georgia case, right, where the employer responded to the garnishment, but then when they applied it, they gave wrong information when they responded, and then they misapplied how they garnished the wages. The employer was held responsible for the full $10,000 judgment against the employee. So now you had the employer paying off the employee's judgment because they did the garnishment wrong. So there are pretty harsh consequences
Wow.
here for messing up the amounts with a garnishment, or again ignoring it in its entirety would have repercussions as well.
Yeah.
So this isn't to scare employers, because again, it's not incredibly complicated what you're going to do. But you need to understand it. You need to account for what the federal law says, for what your state law says, and then make sure it's all coming out and going to the right place.
So if somebody was going to drop from this point of the show on, we're going to get more details, but the thing that they know, you get a garnishment, you notify the employee privately, you follow the letter of the law, every letter of the garnishment. If you got questions, you talk to the agency who sent it to you. and clarify. You pay the bills. This is super black and white, no matter how awkward it may be in reality. Now let's jump into some details about the law. So,
Right.
And tell me if I'm right here, Brian. Like I know some courts when they issue the garnishment to the employer, they're really good because they're incorporating the CCPA's rules into the garnishment order, meaning they'll specifically say, X percent of income up to certain dollars, and if it's monthly, this is the amount. If it's biweekly, this is the amount. If it's semi-monthly, it's this amount. And if it's a weekly payroll, and they really make it easy and black and white that the employer doesn't have to know the CCPA's rules to then properly follow the garnishment. But that's probably not always the case. Is that fair to say?
Right. That's not always the case. And where an employer could go wrong is if maybe the garnishment outlines the restrictions under the state law, which are different than those under the CCPA. And then again, it may be that the state law applies, but again, we'd have to, look at those, against each other.
Got it. Okay. So let's, with that context, let's unpack what the CCPA says about garnishments. What are the limitations of garnishments?
So, right. So as we said, what the CCPA wants to do is make sure that not too much is being taken out from a debtor's paycheck each week, because that then just results in more financial issues and more strain. So what it says is that the maximum part of disposable earnings, we'll get to what that is, of any individual for any work week, which is subject to garnishment, may not exceed the lesser of 25% of disposable earnings for that week. Or, it's a little complicated, we'll walk through it, the amount by which disposable earnings for that week exceed 30 times the minimum wage. So there's a bit to unpack there.
Yeah. We're gonna have to go slower for me on that one.
Yep. And so before I get into those, I'm just gonna point out a caveat that what I'm about to get into does not apply to spousal or child support orders or tax debts,
Okay.
or student loans. So it's other types of garnishments. If it's a child support order, we'll address those differently. There's going to be more allowed to be taken out.
Okay.
But yeah, so getting to these tests, right? So the first one is pretty straightforward. 25% of disposable earnings. So then that brings up the question, what is disposable income, right? So that's the part of the employee's earnings that remain after the deductions for any amounts required by law to be withheld, right? So that's the earnings after deductions for federal, state, local taxes, Social Security, right? This is not after union dues, health insurance, contributions to retirement plans, because those are not required by law,
Okay.
right? So it's only those legally required deductions. So we look at the wages after that, and then 25% of would be allowed.
So up to 25% of the disposable income could be allowed for the garnishment.
Correct. And then there's kind of a little trick to this. So because depending on the amount of disposable income per week, there's almost a little trick that that can be done here. So I'll go through. So right now, the federal minimum wage is $7.25. So, again, you might want to check. You should always check your state law, right? Some state laws might be more generous than the federal law and have a higher different restriction. But with this $7.25 minimum wage, basically no garnishment can be made under federal law if the disposable earnings are $217 or less per week. So that's the first one, right? Earn $217 or less per week, nothing can be garnished. Then we have employees who earn more than 217 per week, but less than 290 per week. In that situation, only the wages above $217 can be garnished. So I'll give an example for this one, right? An employee's gross earnings in that week are $250, right? After the deduction, the federal, state, local deductions, the disposable earnings are now $220, right? So because that's over the 217, money can be garnished, but it's going to be limited to those $3 over the 217. So in that case, only
And
$3.
will it be the 25% of that remaining $3, or all of it is now eligible?
No, so all that entire $3 is eligible.
Okay. Okay.
And then probably where most of us will be at is where an employee's disposable earnings are more than 209 in a week. And in that example, right, this is probably the majority of our workers, but again, depending on, geography and such, it can be different. But for these workers who earn 290 or more, it's pretty simple. Up to 25% of those earnings may be garnished, right? So again, right, an employee's gross earnings are $350. After deductions required by law, they have disposable earnings, let's say, of 320. 25% of 320 is $80. So that full 25%, that full $80 can be garnished. And so out of the 320 in disposable earnings, 80 can be garnished and 240 are paid to the employee.
Got it. Okay.
And then, so there is a complication that arises when employees are paid on something other than a weekly basis. And it creates this complication because the CCPA only talks about this weekly amount, right? So you could have a situation where a state law says each month, right, the employee, 33% of the employee's disposable earnings could be garnished. Or that's it. They, 33%, but that could all be done in 1 week. And so that wouldn't be permitted under the CCPA because that 33% could be taken out in that 1 week, which would be more than 25% that is allowed.
Okay.
So again, there are some complications, but really there's again a little trick the DOL gives us. If there's biweekly, semi-monthly, or monthly pay, basically assume each calendar month consists of 4 1/3 work weeks.
Okay.
And then multiply the number of work weeks by, in that irregular pay period by, 30 times the minimum hourly range. So that, again, it's, this math isn't too complicated. At the outset, it might seem a little confusing, but it works pretty well.
And I've seen people get in trouble with commissions.
Mm-hmm.
Commissions can be lumpy. So you could have an employee who's 100% commissions. They don't have a salary. They're not paid hourly. They're just 100% commission. So that's super inconsistent in how to apply. You could have a more highly compensated person. Maybe they have $50,000, $100,000 base salary, and then they earn commissions on top of that, but it's inconsistent. And maybe it's, maybe they're paid biweekly, semi-monthly, but commissions come a month in arrears once a month. And then there's bonus pay. How do you handle all these non-standard pay period types?
Right. No, so I guess number one, right? So the first thing is that the CCPA applies to quote unquote personal earnings, right? And so as you suggested, these earnings can come in various forms, right? It could be just regular wages or salary, but right, it could also be commissions, bonuses, other periodic, types of payments. And so, those are also subject to the CCPA's, restrictions. And so, when we look at it, if they're being paid on a weekly basis, then again, we're just going through the standard CCPA, analysis. But again, if they're paid, commissions, right? So for instance, in one work, you know, you have a draw that's paid weekly, and then once a month you have a commission that's paid. So, right, you would do this separately for the draws, and then that week when you have the commission, you would do, the same analysis, but including the commission in that week. So, same thing is, vacation pay and sick pay, count as earnings. So if, someone's out, for a week, but they get, vacation pay, that also, right, it's for personal services, right? It's for your employment. So you're still going to have to garnish, those types of earnings.
Yeah, I didn't even think about that. That makes sense.
Yeah. And then, there is, I don't want to get too much into this because it even doesn't necessarily make sense entirely to me, but, courts have even held that once a payment is deposited in an employee's, account, that it could still be subject to CCPA, which, it means, has lots of repercussions of how you would get that money, but let's not go down that road. But yeah, once, if you have not paid the employee yet, even if the money has been earned, right, then you're going to have to go through this analysis, before that pay is issued each time.
Brian, I assume expense reimbursement does not fall in because it's not compensation, it's just reimbursement.
Right. Because those wouldn't be earnings. So right, that wouldn't be subject to it.
Yeah. Okay. All right. What about fringe benefits? So it's obvious if I'm paid $20 an hour and working with 40 hours, it's $800 gross minus my taxes. This all seems very straightforward. But what if I'm working I got a fringe benefit where I get free daycare? And is that part of the calculation because it's earned?
Right.
Or how does all that work?
Yeah, so it's about, fringe benefits. I'm not so sure. The DOL recently issued an opinion letter that went through these various types of earnings. So, I don't believe that those fringes are included in those types of earnings, but, things like a payment from, pursuant to a pension or retirement program, though, right, even though you're retired, that could still be garnished, right?
Yeah.
So, simply because an employee is no longer working for you doesn't mean you can ignore the garnishment order. I mean, you might minimally have to respond, but right, if you're making some type of retirement payments, that could be something that needs to be addressed. I feel this is also leading us to the question eventually of independent contractors as well, which is kind of the two-word phrase we haven't mentioned.
Go down that path because I mean that's a tipping point for about 30 different podcasts around classification and whatnot. What does a small business owner need to know about a W-2 employee versus a 1099 contractor?
Right. So these laws, the CCPA, this is always going to apply to your employees. And in the giving you the answer, probably no one really wants on independent contractors is it depends, right? CCPA,
there's no more perfect lawyerly answer than it depends. Yeah.
Exactly.
All exactly alike. It depends.
So the CCPA doesn't explicitly state whether the garnishment protections apply to the earnings of independent contractors. So what we basically have is various states and jurisdictions saying different things, right? So just to give you an example, Tennessee, Kansas, Iowa, courts there have said that these limitations on how much can be garnished under the CCPA, those apply to independent contractors. But then, states like Nevada and Vermont have said, No, it doesn't apply. There's a wage garnishment against an independent contractor, there's no limitation to how much can be taken out.
Yeah.
So, that is one where I think what employers should know for an independent contractor is don't ignore it just because you receive a garnishment for an independent contractor. That doesn't mean it can be ignored. Um, the the notice itself might give you an indication of that whether it applies or not. But absent that, you may have to get some advice, right? You may have to contact an HR consultant who may know that, or an attorney, because
And
it
and,
becomes
and
a lot more.
my non-attorney advice is follow the damn garnishment, because if the court already has its eyes set on you, and they are attempting to hold you, the employer, accountable for contract worker, and so they're gonna treat you for non-compliance of the order in the same way they're gonna treat the contractor for repayment. So if you start deducting and that contract doesn't, I mean,
Yeah.
it maybe adds a layer of weirdness and awkwardness to the conversation because it's a 1099 contract employee versus W-2 employee. But I, I would just say, don't try playing lawyer here. I mean, follow the damn garnishment, right?
Yeah. And what I will say is that many states fill in the gap that the CCPA kind of omits with respect to independent contractors. And a good number of them do explicitly state, yes, these restrictions apply to employees and independent contractors. Again, it's to fulfill the purpose of the law, right? If the difference between employee and independent contractor shouldn't necessarily dictate whether a huge amount of one's weekly pay or a smaller amount could be garnished, right? So I think a good number of states are acknowledging that and applying it to independent contractors.
Right. I don't
So,
want to go too deep down this rabbit hole because it could be a big one. But we talk on the show many times. You and I have done episodes. Our good friend Mary and I have done episodes on this topic about employee classification. You don't get to choose. There are laws that dictate and determine, and there are tests that must be applied, whether you're exempt, non-exempt employee, whether you can be a contractor, or whether you're an employee. And people get misclassified as 1099 contractors all the time when legally they should be classified as employees. That said, one of the litmus tests for being a contractor is the ability to provide their own tools and subcontract the work themselves. So how does that work? Because we can get our heads easily around a contractor being a human being that's renting their labor to me in a contract worker, right? But it's all there's a continuum from there to being an actual business that hires a bunch of employees to perform work on their behalf. If it's, let's just pick a simple case. You've got an IT person that is an outside contractor to you. They manage your computers and your network, your phone system. They set all that for you, but they have some subs that work for them. What happens when you get the garnishment for the sub of them that you didn't even know existed? Or is that even a thing? Or is it really only the person you're directly contracting with?
right. So typically what we'd expect to see would be that the garnishment is only going to be served on the actual employer or the company that the independent contractor is working for, because typically that's who the creditor is going to find out about, right?
Yeah.
They're much more likely to find out about the company that's actually paying this guy than the company that is paying the company that's paying the employee. So, I can't recall any situations that I've seen where, like the general contractor received it instead of, the subcontractor. But, if that's the case, again, under no circumstances should the company ignore it, right? In that circumstance, you should still respond, and your response may be, we don't pay this person as far as we know, they are a worker for X company, right? That
As
might
I was
be the
asking the
response.
question, I was realizing it's kind of a stupid question before exactly what you just described, but it does make me wonder about like this test of from below 217 a week, over 290 a week, up to 25% of the remaining disposable earnings. If I'm a contractor, I might be charging you over market rate because you don't know it, but I'm actually paying subcontractors under me. So it could look like an inflated available earnings to deduct from the employer's perspective, but that liability really rests on the contractor themselves, doesn't it?
Right, right. I
Mm.
think it would. And then look, one more complication to throw in there, right? Now that we've kind of set the table, workers can get multiple garnishments. And
Yeah.
that becomes complicated. So the first thing I'll say is that it is likely. I mean, I believe over 10% of those with a single garnishment actually have multiple garnishments. So, when there are multiple, there's going to be a priority of which one comes first. And typically it's the support orders, right? Child support orders are almost always getting the first priority.
Yeah.
But what you need to be aware of is that this federal CCPA Act does not say anything about priority. So employers should look to the state law to address the priority of multiple garnishments. So again, reaching out to your local HR consultant or an attorney, right? That's something that's going to be set forth somewhere, but you need to follow it. So that'll tell you if you have multiple ones, which one comes first. And it's very important because there may not be enough, right? Subject, let's say the person earns, $500 a week, right? So it's the 25% limit we're looking at.
Yeah.
There might not be enough money being earned to satisfy both garnishments each week. So, that might mean only one is being garnished or some of one and, all of one and a little of the next. But the employer needs to know which one is coming first. So that's real important. Just to know that you can't select. It's not as if the first one received in time is always the one you're going to follow, right? There are situations where a more recent child support order might take precedent over or priority over some older garnish.
Right.
And then the key is, right, that you need to make sure these are garnishments, right? Like something like a wage assignment is not a garnishment, right? When an employee
Talk
agrees.
about that. What's the difference between those two things?
Sure. So a wage assignment is more of a voluntary procedure where, let's say, an employee may owe a debt, and so they agree to an assignment of X amount of wages each pay period that the employer, deducts and submits to, a creditor. So that might be something voluntarily agreed to,
Okay.
but then let's say you're doing that and then that employee gets a garnishment. The garnishment is the only real garnishment, right? The wage assignment is not considered a garnishment. So
Fair to say that a wage assignment wouldn't come from a court. A
correct.
garnishment would. And so,
Exactly.
well, you as the employer aren't probably legally obligated to participate in this wage assignment. Maybe you want to help your employee. Hey, they're trying to get back on their feet financially. You want to help them repair their credit. You're going to deduct a certain amount. You'll pay their creditor for them. And so you feel like you're being a good human. You're helping them out, but that's completely voluntary. As an employer, you're not legally required to do that.
Right. Exactly.
Yeah.
And so, look, again, when we have these multiple ones and if you have multiple ones that actually are garnishments, then we're going to have to look to the particular state law to see the priority of those. And so again, that becomes a little bit complicated, but once we determine the priority and we know the amounts because we've calculated it, It's really just going one by one, seeing if that has used up all the amount that can be garnished. If it does, all right, it ends there. That's all we garnish. If it doesn't, there's still some left over. Then you can go to the second garnishment. And then you can decide what to do from there. And talking about multiple garnishments, I will make one point that the CCPA has a limited anti-retaliation provision, right? It's limited in that really it just protects employees from being terminated if there's a single garnishment for a single debt. So under the CCPA, if someone is subject to two garnishments for two, there are two garnishments and they're with respect to two different debts, there's no longer protection from termination. But that said, state law may expand those retaliation protections even when there's more than one garnish.
So I'm the employer. I try to run a highly moral, clean, family-like business, and all of a sudden I get a garnishment that reveals some sinister part of this employee's path that I don't agree with. I can't fire him. That's really what this means, right? Are there,
Exactly.
if I make up a ridiculous edge case, are there edge cases where there could be, maybe I'm a faith-based business. Literally, I'm an employee of a church, and there's, I see a garnishment that reveals something that you signed an oath that you wouldn't do. I don't know, I'm making crap up here, but are there any edge cases where, it's easy to see how this could be abused, where employees could be, I don't know, overly judged for their moral character because they have a blemish in their past.
Right.
But
No,
is there any edge case that an employer has any rights here?
I have not seen those. And, one reason for that is, we see limited amount of these discharge actions being filed because there's a split of authority as to whether there's a private right of action or if the Secretary of Labor of the U.S. Department of Labor has the sole authority to bring these. So, there's that in the background, but, what these laws say is that, it's due to the fact of the single wage garnishment. So if the garnishment somehow raised some other issues that became problematic, and the company took action against them because of that, right? They could argue it's not due to the fact of the wage garnishment. It's due to some other fact that led to the termination. What I would say is be very careful with that because, the CCPA not only makes it a civil claim for, that, unlawful discharge, there can actually be criminal. It can be a criminal offense to discharge someone due to a garnishment. So I think that is something an employer really wants to be careful of, especially because the discharge protections will only be stronger under state laws, if anything. And so that plus what's in the CCPA, you really got to be careful. If you're going to consider terminating someone because of an issue associated with a garnishment, I would suggest getting, legal guidance on that because you could be going down
and you and I, we've talked many times on this show. I mean, it's kind of backs into just your hiring practices. And of course you want to hire people of good character. That makes perfect sense. But be really careful trying to play the moral police here as the employer. Hire for skills, hire for culture, hire for things that map to actually performance that you can demonstrate if necessary to a judge that, these are the requirements for the job. And you're almost probably never going to be on very solid ground if it's because, they borrowed too much money and didn't repay it, or, they're a deadbeat dad and didn't pay. I mean, just, stay out of the moral business and focus on skills and competencies, what is required to perform the job. Make that part of your hiring practice, your performance management process, your handbook process. And that will if you're inclined to go there, hopefully you're not, but if you are, that helps you stay out of those waters. Is that fair?
Yeah, absolutely. And look, what I would say, and look, based on the statistics we discussed before, garnishments are just going to be a fact of life for our workforces, right? If you're lucky enough to have not had to deal with one, that's great, but you very well may in the future. And so, like you said, this doesn't mean someone's a bad person or they should be fired. Um, the opposite is actually the intention of these laws, that the employer continues to employ this person so they earn money, so they can make their own livelihood and they can satisfy the debt they owe to a creditor, right? So that is really what the goal of these laws is. And yes, it does put some burden on employers to respond to these garnishments in the correct way. But, I think best practices, you should have a point person, right, who's going to deal with these, right? That's typically going to be someone in HR or maybe even finance because of, what we're dealing with here. And then look, the first thing, the first step, if you receive a garnishment, respond to it, right? They often have a response requirement, before money is, has to be garnished. So respond, inquire with questions. If there's someone to ask, if not, engage, with your own resources, right? A shore or an attorney. And then, make sure you implement these internal practices so that you can, replicate this in the future. And I think, those are key. Not ignoring it, not being loyal to your employee is a real key here. That yes, you're being loyal by still employing them, but you can't be loyal to the extent of ignoring the garnishment or trying to get around it. That's only going to have repercussions for the employee.
As always is the case, you don't get to make HR policies that circumvent the law. So, Brian, I think we covered all aspects. I'm sure you can always go into more nuanced cases, but I think we hit the guts of it. And I won't even attempt to recap because I think you just nailed it perfectly. Any other final guidance that you would give small business owners here?
No, I think that's really it. Don't just ignore it. If you're not sure what it is, you have the duty to figure out what your obligations are. And they're not too complicated once you set up some processes and, wrap your head around, what the steps are here.
Yeah. And for people newer to the business world, maybe you've hung out a shingle, you're just starting a business, you've never faced this before. This can be intimidating. It's like, boy, I feel caught in a rock and a hard place. I probably know too much information. This sounds like some legal thing I got to follow, but how should I handle this? If you don't feel comfortable, call, contact an attorney like Brian, contact Assure. But I would probably encourage people, the fastest, cheapest, easiest thing, contact the person, the agency who issued the garnishment in the first place. They'll probably be pretty helpful. They want the money. And so they're going to help you comply with the law, and comply with that garnishment and clear up any questions you probably have. That's probably the fastest, easiest thing you could possibly do. So we know it's complex and can be intimidating for folks going through this kind of stuff for the first time. So as you add employees, it's not a matter of if, it's a matter of when you're going to face this. You're going to have to deal with it. You're going to have to deal with it in a legal way. So Brian, thanks for unpacking this topic for us.
Thanks again, as always.
And as everybody is growing their business, thank you for another week letting us be part of your mission to grow. Until next week. That's it for this episode of Mission to Grow. Thanks for joining us today. For show notes and more episodes, visit us at missiontogrowth.com. If you found this content valuable, I invite you to share it with a friend and subscribe to the show. If you really want to help, I'd love it if you left a 5-star review on Apple Podcasts, YouTube, or wherever you listen. Mission to Grow is sponsored by Assure. Assure helps more than 100,000 businesses get access to capital, stay compliant, and develop the talent they need to grow. To learn more about how Assure can help your business grow, visit assuresoftware.com. Until next time.